Hello, everyone. I'm Bob Goulder, a contributing editor with Tax Notes. Welcome to the October edition of In the Pages, where we take a closer look at some of the content that's appeared recently in our print and online publications. Today, we're going to examine the tax proposal that's come out of the House Ways and Means Committee a few weeks ago. And if you're keeping score now, that would be the third tax plan that's now circulating around Washington, D.C. What are the other two? Well, first you have what was contained in the Treasury's Green Book that we usually refer to as the Biden tax plan. And then the second one would be that discussion draft that was released a couple of weeks ago by three Democratic members of the Senate Finance Committee. So just to be clear, we're not talking about those, we're talking about the Ways and Means bill. Now, that bill's received a lot of attention. We've published plenty of content about it in the pages of Tax Notes, but most of that concerns what Congress should do with the corporate statutory rate or how it should change the GILTI regime. All right. Here today, for purposes of this session, we're going to be a little bit more granular in our critique. There are two provisions of that Ways and Means bill that seem to have sort of flown under the radar screen. They're not getting the attention they deserve. Yet, if enacted, they would significantly alter Subpart F as we know it. Well, our featured piece of content for this week lays all of this out in detail. And it was written by Professor Jeffery M. Kadet with the University of Washington School of Law. It's titled, Ways and Means Bill Lobbyist Change, Less Subpart F, More Profit Shifting. And I'm delighted to say that the author of this piece is with us here to discuss it. Professor Kadet, welcome to In the Pages.
Well, thanks for your welcome. It's a pleasure to be here.
Okay, let's get right to it. Your piece in Tax Notes, it has a certain tone to it. It's as if you lament the inclusion of these two provisions in the bill. And if enacted, they would change the rules for some concepts that tax people are pretty familiar with. Foreign-based company sales income and foreign-based company services income. And you write that these changes, if enacted, would weaken Subpart F. Can you explain?
Sure, happy to. Subpart F, of course, in the, let's say, large scheme of things, tries to look at situations where corporations would create possibly, artificial structures to place profits that might be more properly earned in a place where real activities are conducted, to place profits in a controlled foreign corporation that would be taxed, of course, at some lower level. And the rules define these categories: foreign-based company sales income, foreign-based company services income, also, of course, foreign personal holding company income. And this is, this focus on types of income has been around since the formation of the Subpart F rules back in 1962. So, these things have been around for quite a while. With regard to foreign-based company sales income and services income, there's sort of I think, a simple way to think of them, and that is look at the location and look at whether a related party is involved. So, for example, foreign-based company sales income is the point of origination of whatever product is being sold outside the country of incorporation, is the point of destination outside the country of incorporation, and is a related party involved. If those conditions are met, then you have foreign-based company sales income. Now, when Subpart F was passed, there wasn't a focus on is the taxpayer saving US tax, or is the taxpayer saving tax in some other foreign country where where another CFC of the group is operating. And this has been a consistent feature of the foreign-based company sales rules since inception. Now, one of the changes would make the related party only applicable if it's an operation in the United States of that group, and would say, forget about, in essence, any related parties within the group that are in other countries. So effectively, this is what you might call a beggar thy neighbor issue. The change would eliminate from Subpart F treatment, from foreign-based company sales income, any transactions that involve, outside the country of incorporation for manufacture, origination and destination outside the country of incorporation. But the related person condition, if the related person, for example, is another CFC, so that some other country is, its income is and potential tax collection is being fleeced, that is being said to be okay. It's not going to be in Subpart F any longer. So this kind of thing. And the same thing on the foreign-based company services side. This general condition is, are the services performed outside the country of incorporation and as a related party somehow involved? And if the related person is a non-US part of the group, then again, no longer Subpart F income under this very innocuously created change, which you really have to get into the weeds to even find.
There's a lot there to unpackage. I mean, we're talking about really messing with Subpart F here. Now, to be clear, these concepts, foreign-based company sales and services income, they're not eliminated, but their scope is, it sounds like their scope is being significantly narrowed. How is that likely to change cross-border tax planning?
Well, I think let's start from a premise, of course, that multinationals and their advisors have been very active in searching out pretty much anything that will save their client if they're an outside advisor, or save their company if they're an in-house person. Companies and advisors have been very, very aggressive at trying to move things around, whether it's just in paper or whether it's maybe occasionally actually changing operations to get a better tax result. I think the vast preponderance of profit shifting structures involve changes which are paper only, as opposed to changing the actual operations. But the point is that in attempting to set up profit shifting structures, there have been certain constraints. What are the US Subpart F rules? How do we structure this particular thing to sidestep those rules? How do we structure something so that we also move income out of a country where real operations are taking place and place them in a tax haven or other low tax location? How do we do these things? So there's, in a sense, two constraints. Well, by narrowing the scope, and that's a wonderful way to say it, Bob, by narrowing the scope of Subpart F, you've just, in a sense, expanded what companies can do in terms of their ability to come up with structures that will meet whatever constraints are left, whatever fewer constraints. And I think with the very evident situation in the future where we can expect a similar domestic rate. I mean, currently 21%, and the general rate of 10.5% for taxation on guilty. There's going to remain the incentive, the very strong motivation to continue shifting. That's not going to go away.
Jeff, that's very much in keeping with the title of your article. What we're looking at here truly is a case of less Subpart F and more profit shifting. Now, one of the points you made in your piece was about spillover effects. You say anytime you do something to enable more profit shifting, you're going to get spillover effects, perhaps intended, perhaps unintended. Can you comment a little bit more about what you mean by these spillover effects?
Okay, what I mean is the focus of this, and I think you'll appreciate that if we look back to, I believe it was 2006, that was when Section 954C6 came in. That was the flow-through rule for Subpart F, foreign personal holding company income, which essentially said for foreign personal holding company income, it's okay to shift royalties or interest, things like that, from one CFC to another CFC. And what that did was, opened up the door to a lot more profit shifting out of other countries, since, again, the Subpart F constraint was lifted. If we further put constraints on Subpart F, if we lower how much, again, Subpart F can be a factor, there will be more motivation not just to pull income out of other foreign countries with the US having a beggar thy neighbor approach, but I think it will also further encourage new profit shifting structures, whether through cost sharing agreements or other things, which will again have the effect of pulling more income, more current taxation out of the United States and into CFCs. So I think that's what I would call the spillover. In other words, the focus may be just, gee, it's okay to shift profits out of foreign, group members, other countries, but don't do it from the US. But this greater ease is going to encourage further additional structures that will have the effect of pulling even more out of the US.
You have criticized not only the substance of these two provisions, but also sort of the procedural aspect or the transparency aspect, if you want to mention that. Even though we're messing with Subpart F, it wasn't included in the Ways and Means summary, and it wasn't included in the JCT chairman's mark. Is that right? What's going on here? What explains these omissions?
Well, first of all, let's, I didn't mention another thing that I could have mentioned earlier and probably should have, but there was, of course, mention in the section by section summaries that both the committee that the Ways and Means Committee put out, and also that the Joint Committee on Taxation put out. There was mention of this in very briefly, but what was totally not mentioned was that the long beloved branch rule, which is part of the foreign-based company sales income rules, the branch rule would be completely eliminated. And when one goes through the draft language of a bill, or if a new law comes out and you go through the language of the law, you look at it and you of course see the words that are in the the draft, but what you don't see unless you go and look for them is what was there before, and gee, what's missing, now in the new law. So section 954 D2 is where the branch rule is. And I'll say in a moment or so what the branch rule is briefly, but in this very, what I'll refer to as almost under the cover or innocuous manner, the bill says, okay, we're going to put in place a new section 954 D2, and it's going to read, limitation on, coverage of foreign-based company sales income. But of course, there's silence on what was there before, and what was there before was the branch rule. So the branch rule disappears by this, at least on the surface, innocuous change. Now, what's the branch rule? And is the branch rule, really significant? Well, the branch rule was originally there because, again, 50 years ago when, or I guess 60 years ago now, when Subpart F was enacted, generally there were, different CFCs in each country, but it was realized that if a group had a CFC in one country and that CFC had a branch in another country, and if the way the rules worked out, I mean, for example, maybe there was a CFC that was manufacturing a product in Germany and then selling through a Swiss branch, and through the German tax system and the Swiss tax system, in a sense, a lot of income which is related to what you might call the sales profit, the profit from the sales activity, as opposed to the profit from the manufacturing activity. A lot of that was taxed either at a very low rate or maybe not at all. So the branch rule said, gee, if you're doing stuff through a branch and you have the same effect as if the branch were a separate CFC, then we're going to call that Subpart F income. So this branch rule has been around forever. It's got regulations which sadly are some of the most terrible to read, throughout all of, the income tax regulations, and that's, I guess, a pretty big condemnation of them. But in any case, they are miserable to read. The long and short, though, is that especially since '97, with the advent of check the box, with the advent of the ability to have one CFC with disregarded entity subsidiaries in 5 or 10 or 100 other countries underneath, all of this treated for US tax purposes as one CFC which has divisions or branches in various places around the world. The branch rule, in essence, has become more important. Frankly, my guess, and especially after seeing, Bob, you'd written an article recently on the Whirlpool decision. Seeing how egregious, frankly, the facts were in Whirlpool, they should have been voluntarily filing on this basis, as opposed to pretending that the branch rule doesn't exist and trying to claim these various things in court. So if Whirlpool is a good example of how the branch rules have been frankly either ignored or very, very aggressive positions taken with regard to their coverage, and especially considering that with this IRS victory on Whirlpool, that perhaps the IRS will spend a little bit more time looking at these structures where there's one CFC and a whole bunch of disregarded entity subsidiaries underneath, this elimination of the branch rule prospectively seems like a relatively major thing, revenue-wise, as well as taking away something that we know and love. And anybody who's actually read through those terrible regulations sort of feels like he's got a sheriff's badge or something on his shirt for the accomplishment. But anyway, it would be terrible for it to go away, both personally and I think revenue-wise.
Yeah, and not just go away without being included in the Ways and Means summary or the JCT chairman's mark. So the sort of transparency aspect there is a little bit interesting.
You're right, and there's one more aspect to this, in a sense, disclosure of what's going on. Looking at the Joint Committee on Taxation Revenue Estimate, if you look at the section that these two changes are included in, it says over 10 years, there's I think a $20 billion revenue gain. So in a sense, anybody who is maybe looking through this without the, spending the time to see what's missing and what the significance that might be, anybody looking through this, this revenue numbers sees, gee, this section, 20 billion revenue gain, sounds good. Let's go on to the next item. Now, I don't know, of course, how the Joint Committee, made its estimates. There's, of course, a bunch of other things in the same section. So perhaps they included a bunch of gains from some of these other items, and that masks the loss in revenue from this constraining Subpart F. I don't know, but the point is that, again, from the standpoint of making this as obscure as possible, in other words, not only is it hard to find as you look at the bill, it's also not something that's going to attract your attention if you look at the revenue estimate.
Very interesting point. Now, the Whirlpool case, as I recall, that involves pre-TCJA tax years. But now, it's after the enactment of the Tax Cut and Jobs Act of 2017. So let me just put this out here. Let me play the critic for just a little bit. If somebody says, all right, we're going to have less Subpart F because we're just, emasculating the branch rule, just getting rid of it, shrinking the scope of these provisions for foreign-based company sales and services income. Does it matter if that income is then picked up by the GILTI regime? In other words, should your concerns be somewhat ameliorated by the idea that, okay, it's going to be out of Subpart F, but look, it's probably going to be picked up by GILTI? Your thoughts on that?
Okay, you're absolutely right that if anything is not in Subpart F, it will slop over into one of two categories. Number one, to the extent that there is qualified business asset investment, lovingly referred to as QBI, then some of that income will go tax-free under the participation exemption. Now, if maybe it's not that common for a lot of these companies, especially in the internet area. They have a lot of fixed assets, so maybe that's not a large part, but for some industries it, of course, may be material. But of course, when we look at the rest, which gets slopped over into GILTI, then we're looking at, yes, taxation, but at the low GILTI rate, which currently there's a 10.5 point differential. If we look at the Biden proposal, there's still a 7-point differential. If we look at the Ways and Means, it's roughly about 10% or a little under 9.5%. Because I think they said the guilty rate would be around 16.5% with a 26.5% domestic rate. So that's again around 10%. And the 3 senators from the Senate Finance Committee, they're remaining mum, so to speak, with regard to how much difference there would be, but at least what they've drafted contemplates that there would still be some amount of difference. So to the extent that there is that difference, it encourages multinationals to move profits out of the US and into some sort of international structure that will allow them to say, gee, this is guilty. We get this 10-point or whatever it happens to be tax differential, which helps the bottom line in earnings per share and affects equity-based compensation. I mean, there's motivations for management to look for these things, and they do.
So when it's out of Subpart F, it's either getting a nice rate preference by virtue of being guilty, or it's just under QBI and therefore under the participation exemption and not being taxed at all in the US.
Summarized outstandingly.
Yeah. So a clear incentive. Okay. We have time for one more question, Jeffrey. Let me just ask you, what should Congress do?
Good question. As you might have gleaned from some of the things I've said, I think from a policy standpoint, we ought to try to achieve a few things. One thing is that we should have, and to me this is particularly important, there should be a level playing field between pure domestic businesses and multinationals that operate both inside and outside the borders of the United States. Right now, there's clearly an advantage. A multinational, whether it's through actually putting operations overseas, or whether it's merely through some of these, profit shifting structures, they put profits outside the United States, and we have, in a sense, a very uneven playing field between pure domestic companies and multinationals. Now, if you listen to, of course, lobbyists and the multinationals themselves, one of the things that they, simply cry about and, are constantly whinging about, I guess is maybe another good word for it, is the fact that, gee, we have to remain competitive against our foreign multinational competitors. And yes, of course, I agree they need to remain competitive. But, is this crying out as to how important this is this merely a red herring or is it real? And I think if you try to look at the granular level as opposed to just the general statements that they make, it's going to be on a case-by-case basis whether there will be, in a sense, any competitive difference. And in some cases, frankly, the foreign party may be at the disadvantage. You have different CFC rules in different countries. You've got different industries as to where they are operating and what tax regimes their operations are subject to. So in some cases, yeah, maybe a US company might be a little worse off. In another case, a foreign multinational might be a little worse off. So, you know, it's not just a one size fits all that every US multinational needs a lower GILTI rate in order to be able to compete effectively. I mean, it's if we look at what you know, US industry and US business has done, they've been rather successful on the world stage. So I think at best this is a red herring. And I think from a tax policy perspective, it's more important to have fairness between pure domestic business and multinationals. That's more important than this possible red herring. Now, one other, you know, general tax policy comment is, of course, that taxes shouldn't direct, you know, and influence unduly where you're going to conduct operations. It shouldn't unduly influence the structure you use, whether you decide to put a company here, a company there, or you know, what your structure is. So from a tax policy perspective, it's better to have something that is neutral so that structures and operations can be done without tax being a factor. Now, the obvious specific thing that ought to be done in order to achieve this is make the domestic rate and the GILTI rate the same. And also presumably do away with the participation exemption, but on the basis that that's probably either going to go away or be made smaller. I think that's sort of a smaller issue that goes to the side. The big issue is make the domestic rate and the GILTI rate the same. If you do that, you take away the motivation to, whether it's move operations or whether just through paper moving profit outside the United States. You take away that motivation. Now, I think it's fair to say that with President Biden and the Ways and Means Committee assuming that this differential will continue, and the 3 senators from the Finance Committee being maybe a little bit more open to that going away, probably it's going to remain. So if it remains, what I've suggested through a submission to the 3 senators, and also that I communicated to the Ways and Means Committee, is add to section 250, which is the GILTI deduction, the special deduction, which is how which is the mechanism for the lowering of the effective tax rate from 21% to 10.5%. Add to that section 250 a limitation which makes the grant of that deduction proportional to the effective tax rate on the GILTI itself. So if you have GILTI being earned by a tax haven which has no tax on it, instead of that being allowed the full deduction, you'd look at it and you'd say, well, gee, the numerator, which is the amount of, the effective foreign tax rate, is 0. The denominator, which is the section 11 tax rate, is 21% under current law. So gee, they get 0 section 250 deduction. If they had actually paid, let's say, 10% of foreign tax, then the deduction would be allowed to the extent of that 10% over 21% times the deduction. Now, whether anybody will, latch onto this brilliant idea, I don't know. But if they were to do so in a easy legislative manner that allows them to retain all the GILTI rules and the GILTI deduction, it would discourage the profit shifting by, in effect, disallowing that guilty deduction to that extent.
There you have it. Words of wisdom from the professor as to what Congress should do in regards to these issues. Professor, thank you very much for joining us. Again, the piece is titled Ways and Means Bill Lobbyists Change, Less Subpart F, More Profit Shifting, and you can find it in the September 27th edition of Tax Notes International. And Professor, we hope you'll write for us again soon.
My pleasure.
That's it for today. Thanks for joining us. See you next time. Want more like this? Subscribe for more tax videos. Special thanks to our executive producers, Jasper Smith and Paige Jones, and showrunner and video editor, Jordan Parrish.